Hello, I'm Sarah McNamara. I'm the lead judge in the Specialist Domestic and Family Violence Court in Alice Springs. The court sits in this courtroom every week. It has been doing so since 2020, and its commencement followed extensive stakeholder consultation between the court and the department and stakeholders in the community, both across the justice community and social services community as well. The court's had enormous interest and support. The overwhelming majority of matters that this courthouse in Alice Springs deals with on a day-to-day basis are family violence related. There was a broad recognition that traditional responses to family violence was not achieving satisfactory outcomes. It was not curbing recidivism rates. And in fact, we've seen steady increases in those rates in recent years. There's been a lot of interest in trying a newer approach. The beginning of the court coincided with a full refurbishment of the court space, primarily aimed at ensuring that the court was a safe space for victims of crime. The refurbishment includes safe waiting area for victims of crime, has a separate lift access that leads down to a separate entry point into the court building. It also has direct access into the vulnerable witness recording area, which is where a witness may choose to give evidence direct into the courtroom. In sitting in this space, they can choose whether or not they are seen by other members in the public gallery, including the defendant, or whether they just want a direct line of sight with the judge. All designed to enhance the sense of safety that victims feel when they enter into the courtroom.
What we really love about the specialist approach is the focus on accountability and the importance that's placed on the user of violence accepting accountability and engaging in an accountable way with the actions and the harms that have been done in the past, and a real focus on the safety as well of the victim survivors. The combination of an accountability focus for the perpetrator and a safety focus for the victim survivor and the family of the victim survivor as well, I think is what really underpins the whole model and makes it so strong. The outcomes that we see from the specialist approach are really positive. We see really long-standing improvements in the conditions of living, of safety that our clients are experiencing.
The program is a bail program. In terms of the participants, it's for defendants who want to plead guilty, who are prepared to take full and genuine responsibility. It's also about holding those people to account for what they've done, and at the same time giving them an opportunity for rehabilitation, therapeutic interventions that steps a defendant through the dynamics of family violence, the impacts and strategies to ensure that family violence is something that they choose in the future not to use. Defendants also must consent to the participation of a victim in the process. This is all consented to in a consent form that must be completed and tendered to the judge prior to being admitted to the program. At every review mention, the judge will take into account the views of the prosecutor as to whether or not bail should be continued, but importantly, any views known of the victim survivor in assessing whether or not bail should be continued, and the defendant should have the ongoing opportunity to participate in the court program. Along the way, the court considers all risk factors, all criminogenic risk factors that may have contributed to an offender's offending behaviour. Aside from the re-education around use of family violence, there are other considerations that may arise as relevant along the way, such as unstable housing, alcohol and drug addictions, and the need to address those criminogenic risk factors in a meaningful way to ensure that when the program's completed, a defendant will leave this building and not re-enter for any offending purpose. At each review mention, the court will receive a participation notice from the Men's Behaviour Change Program to indicate the progress that a defendant has made in terms of that particular program. Where relevant, a risk notice might be tendered to the court indicating that there have been, for example, police involvements, at which point the judge will generally address that at the outset to make a determination as to whether or not it's appropriate that the defendant continue in the program, or whether a level of risk has arisen that makes that continuance untenable. A key feature of the program is managing risk and ensuring the safety of all parties, in particular victim survivors who are participating in the process. At the outset, the court calls for a risk assessment to ensure that the court is alive to the potential risk factors that may arise along the way. If satisfied that the risks can be appropriately managed, the court will admit a defendant to the program where bail is an option. When admission is being considered, the Domestic Violence Registrar appointed by the court will contact victim survivors to gauge their views on the defendant's participation in the program, and also to inquire as to whether or not they wish to participate in the court process and whether or not they require supports in doing so.
When a man is referred to the specialist court, I'll then go into the prison, I'll assess that man. If he's suitable for our program, I'll write a letter to the court expressing that we found him suitable for our program. I'll also do a comprehensive risk assessment and inform the court of that risk assessment. And then I've also afforded the opportunity to make recommendations around things like alcohol rehab, drug rehab, other forms of counselling, other forms of support. That's handed to the judge, and the judge takes those recommendations and that risk level really seriously in deciding whether or not that man can come onto the domestic violence specialist list. My role is a men's behaviour change facilitator, but I also work in the court with the specialist list. So the judge will ask the defendant, what have you been learning in group? And it's a very casual conversation, and it affords the defendant a chance to exhibit what he's learning and what he's taking out of the program. Sometimes I will support him in the way of prompting his memory. What I won't do is try and save him. If he's not taking in anything from the program, then it's important that the judge sees that. But at the same time, it can be a very nervous time for that man. He can feel shy, he can forget what he's talking about. So I do my best to support him, and I also sometimes will need to field questions from the judge. The judge might ask me questions about what we did in the group, or I want more clarity around that. So that's what my role is in that. My red line is if he's doing anything that's unsafe, that I need to report it to the judge. That's not a secret, we're very transparent about that. But I'm also there to support him to have a better life free from violence, and provide him with a range of strategies and different ways of understanding his own emotions and making better choices. When we start pathologizing or criminalizing men and saying he's a monster, he's a wife basher, that doesn't stop recidivism. That really just paints him into a corner. And what this court does really well is it offers a way out. It offers an inclusion, like come in, we'll support you, we'll help you. You've got to take the responsibility, you've got to take the steps. But it's, to me, is far more effective than go serve some time in prison, come out with no supports, and who knows what's going to happen.
While numbers are low in the program, and that's largely due to resourcing issues, we have had a number of great successes. Recidivism rates amongst the cohort of men that have completed this program sit around the 30% mark, and that compares favourably to the approximate 60% recidivism rate experienced territory-wide. Our internal review processes indicate that amongst the cohort of men who have completed the program, there has been a de-escalation in offending in terms of the gravity of the offending, and there's also been sizable gaps in time noted between completion of the program and the further offending.
CAFLU is an Aboriginal family legal unit in Alice Springs, but we also cover Barkly region as well as other remote communities around Alice. And we do mostly legal support for Aboriginal women So we do the Barkly region as well as other surrounding remote communities around Alice Springs. And part of our role is we offer legal support for women experiencing domestic violence. As well as that, we cover a lot of the non-legal supports when they work with lawyers.
So I'm a specialist domestic and family violence lawyer. What that means is I focus primarily on domestic violence within the courts and how we navigate that, often through DVOs and also things like how we put the victims' views before the courts. So Kiefer and I, we work equally and together. So Kiefer, this is her backyard. She's Indigenous and she's also a woman. And that insight is something that is so valuable.
Because it is a therapeutic court, you have that space where it's like 16 weeks to build that rapport with these women and just get to know their story, and then giving their voice in court, trying to, because a lot of the times, unfortunately, their voice does get sort of cut off. And so I think having that 16 weeks is really good. We usually work with the men's behavioural change program, but also the women's shelter partner contact. And with that, they reach out and then refer to us if there's any legal support.
What we find is that 9 times out of 10, the view we're putting before the court from the victims is, we love our men and we want them to be rehabilitated and we want them to have these services, and they want it to be done in the best way possible. And that's what we're finding out is the story of these women and the victims of these intimate partner violence. They want their men to go to rehab, come back, continue counselling and work with them for a long period of time so that they can have a better family unit. It absolutely is better than a standard criminal court. It's much more meaningful. It gives voice to the victims. It gives us time to consider what that post-sentencing plan looks like and how we can long-term case manage the rejuvenation of the relationship.
We have a gentleman that is about to complete the program. He's got a couple of weeks to go at the time of filming. It's been great for him specifically. He has a very young child. When he started the program and through the program, we've been able to amend some of his bail conditions to allow him better access to the child and also some contact with his partner, which typically that is limited while they're undergoing the program because they've generally committed the violence against their domestic partners. So he's had some more relaxed contact with her, still quite controlled through the program. And I think it's great to demonstrate to him the importance of those orders, and he's been able to see that when he's sticking to it, the court then will relax some of those stuff and engage, and his engagement in the program has been so good that the court has allowed some relaxation of those strict conditions. And the whole idea of that again is trying that when he exits the program that he doesn't reoffend. He will have a domestic violence order in place, a therapeutic based program that lasts for about 16 weeks is what we sort of tend to tell our clients if they're going to engage in the program. It's something when we talk to the clients initially about the program, really try and get them to understand that it's not an easy program to enter into. So it involves a lot of time spent with people like the Tunganjira Men's Behaviour Change Program, attending weekly sessions with them, but then also coming back to the court and giving the judge an update directly. And that's something we've really got to be very clear with them that that's something they're going to have to do, is sit in court alongside us, so sit at the bar table, but actually tell the judge what they're doing and how they're looking to change their ways and not reoffend, specifically in domestic violence, is really focused on changing of mindset in that space and trying to prevent them from coming back to court for those type of matters. It's not a program for everyone. We certainly have had cases where people have been exited from the program midway through it. It's a very tough program to participate in for the men that are involved. Do the program while they're on bail. They have very strict bail conditions as part of that, and then they have to be engaged in the program to continue with it. But the success rate and the reoffending rate is quite low. Anecdotally, from what we're seeing, the program is not 10 years old or anything like that, but the signs are really good from what we're seeing in it so far. The Men's Behaviour Program, which is run by Tungunjira Council here in Alice, already existed, and it's something that people can engage in outside of the program as well. But it can be self-admitted or self-administered to the program. It can be part of a suspended sentence condition, that corrections may involve them in the program. But this specialist domestic violence list and program run by the court makes them stay engaged, and then makes them actually come and talk about the program with the judge, either Judge McNamara or Judge Hopkins, and sit and actually talk through the program. So it really puts the focus on do this as part of your pre-sentence. So it's all pre-sentence. They will still get sentenced at the end of the program. I suppose it's the way the court is looking and going, we can't just keep doing the same thing and not get a different outcome. We've got to try things to really look at ways we can curb domestic violence.
The specialist court differs to the normal duty bail and arrest court because the defendant sits at the bar table with their lawyer. Generally, well, they always need to be on bail, so they're not incarcerated in the dock. Already there's a completely different use of the space, and the courtroom is utilised in a totally different way to the defendant's usual experience before they've pleaded guilty. The defendant sits at the bar table, their lawyer sits next to them. The policeman or woman sits, the police prosecutor, I should say, sits at the bar table as well, and the judge tends to ask them a series of questions about what they've been learning about in the men's behaviour change course in that last 2 weeks. The specialist court is a strange experience for a lawyer. It's certainly not an adversarial advocacy setting, it's more interventionist. A lot of the times, as the legal representative, I won't say a word. It's quite a bizarre experience to be sitting with your client while they're doing all the work and really advocating for themselves. And often, you're just sitting there really more as a form of social support and to ensure that there's no incriminating content really, but certainly there's a tension there. It's not the usual course of things. So as a lawyer, it's a bizarre experience.
I'm one of the judges along with Deputy Chief Judge McNamara, and my role really is primarily to make decisions about who should be put on the list. So to make assessments about really questions around risk, to ensure that we have people that are going to have a good chance of success, and also questions around, I suppose, whether or not they've got the strengths and the capacity to really make it through what's a challenging process. Once a person is given bail onto that list, it's then my role, along with Deputy Chief Judge McNamara, to supervise the process of check-ins to ensure that there's compliance with bail conditions. But more than compliance, it's really about connecting with the person who's going through what's a very difficult program within the Men's Behaviour Change program, where they're doing a lot of hard work, and, if you like, listening to them being part of their journey, and reflecting back from a judicial perspective when they're doing well, when they might need to be encouraged, along with, if there are slip-ups along the way, addressing those questions. Someone's granted bail, they can have their bail revoked. So we'll get a report each week about whether there are any concerns. The police will inform us. So the first question in court usually goes to the police. I'm often asking them to reflect what it was like when they first went into their men's behaviour change with the other men and started talking, and how quiet they were and feeling shameful and so on. And then what it felt like to open up, start to be vulnerable, and then start to see their strengths, see the strengths in others. So I think there's, from a judicial perspective, you can observe that kind of change. Perhaps we'll leave it to statistics to determine the ultimate result. But one thing I will say is that unless you're harnessing somebody's strengths, you're really losing an opportunity to bring about change. And that's really the change that that person needs, the people who love them, and the community needs, because that's what addresses, the real harms of domestic violence. I suppose one of the other things that's really stand out is listening to some of the participants go through and talk about their own experiences as children of being unsafe and what that was like for them and how they felt, and to really physically talk about that feeling. And then to reflect on where they are and where they're trying to be in terms of being safe fathers, safe partners, and how they understand their partner will feel, their children will feel, if they're able to maintain that kind of difference. And you know, in the context of First Nations experience, you know, many of these young men live in a context where, you know, the fabric of their own societies and authoritative structures are significantly damaged and frayed. They have grown up around a lot of violence, a lot of drinking, and so it's as if they have to create that safe space understanding through their hard work and through the strengths and connections they have, because it's not something that they were privy to or they experienced as young people. And that's, I think, pretty humbling when you come from a privileged perspective as a judge and you haven't been through that experience, to watch people come out of that, see that, talk about it, and then really follow through within that short course of a 16-week program to look for and then aim for and then work towards that difference.
The feedback from the men who have completed the program has been interesting too. Exit interviews have indicated that they find the process a far more meaningful process. Of particular note in terms of the exit interviews that have been conducted with the men who've completed the program is the fact that they highlight an experience of the court that has been a fair one and a just outcome. One thing that is regularly highlighted by those that complete the program is that they felt that they've been listened to and that their voices have been heard as well. It hasn't worked in all cases, but when it has worked, it has been life-altering for not just the victim survivors and the men who complete the program, but for their children as well. And that is a really important aspect of the changes that we are trying to effect through offering this program.